The summons didn't accuse him of anything. That was the first thing Roman Belak noticed. No charges, no claims, just a notice of participation. You are required to appear as an involved party. Involved. Roman reread the word several times. He was an architect. No criminal record. No disputes he could think of. The letter referenced a civil case he barely remembered. A zoning objection filed years ago by a neighborhood committee he had once advised. He hadn't even testified. He had given context. Apparently, context was enough. The courthouse was quiet when Roman arrived. Not tense, organized. People moved with purpose, holding folders like shields. No one looked afraid. They looked prepared. Roman checked in at a desk. The clerk glanced at his name, nodded, and handed him a badge. Observer, limited participation. Am I a witness? Roman asked. The clerk smiled politely. You're part of the record, she said. Record. Roman took a seat in the hallway outside the courtroom. The case ahead of his was called. Then another. Each one moved quickly. No raised voices, no visible conflict, just procedure. When Roman's case was announced, the doors opened without ceremony. Inside, the room felt smaller than he expected. The judge didn't look up immediately. The lawyers didn't acknowledge him. Roman sat where he was told. The case began as if he weren't there. They spoke about him in the third person. Mr. Belak's assessment influenced the committee's position. His involvement contributed to procedural delays. While not responsible, his actions were relevant. Relevant. Roman raised his hand instinctively. I can clarify, he began. The judge looked up then. You'll have an opportunity if needed, she said calmly. Please let the process continue. Process. Roman lowered his hand. He told himself this was normal. Courts were formal, structured. Still, something felt off. No one had explained his role. Not defendant, not witness, just present. As the hearing progressed, Roman realized something unsettling. Facts were being framed, not inaccurately, but selectively. Context he remembered clearly was summarized into neat conclusions. Nuance disappeared. When a lawyer referenced a memo Roman had written years earlier, he didn't recognize it at first. Then he did. Only the middle paragraph, stripped of the cautionary notes that followed. Roman leaned forward. That's not the full statement, he said quietly. The judge glanced at the document. The excerpt is sufficient, she replied. Sufficient for what? The hearing ended abruptly. No verdict, no decision, just a note that deliberations would continue, on record. Roman stood slowly. No one stopped him. No one dismissed him either. Outside, he asked the clerk what would happen next. You'll be notified if your participation status changes, she said. Changes how? Roman asked. The clerk smiled again. That depends on how the case evolves. Roman walked out of the courthouse feeling strangely light, not relieved, unanchored. He hadn't been judged, he hadn't been accused, but something about him now existed in a place he couldn't see. A record. And once you're part of a record, you don't get to decide how you're remembered. Roman expected a follow-up notice, a date, a summons, something concrete. Instead, nothing happened. Weeks passed. Life resumed its shape, but with a slight distortion. Emails from clients took longer to answer. A permit he'd been waiting for stalled without explanation. A colleague mentioned casually that Roman's name had come up in a planning meeting. Not negatively, just as context. Context again. Roman requested access to the case file. The request was acknowledged, then delayed. then approved in part. What he received wasn't a transcript, it was a summary. Selected statements, key excerpts, annotations marked procedurally relevant. His words appeared throughout, clean, professional, but subtly altered. Hedging language removed. Conditional phrasing flattened into conclusions. Roman recognized his voice, but it no longer belonged to him. He contacted the clerk to ask how he could submit a clarification. She listened patiently. "You may submit an addendum," she said. "It will be attached to the record." "Will it be considered?" Roman asked. The clerk paused. "That depends on its relevance," she replied. Relevance, Roman was learning, was not objective. It was contextual. He drafted the addendum carefully. Neutral tone, no accusation, just clarification. He submitted it. Days later, the status updated. Addendum received, under procedural review. Nothing else changed. Roman attended another hearing weeks later. Not summoned, invited. His badge this time read, "Interested party." Conditional on what? Inside the courtroom, the atmosphere was the same, calm, efficient. This time, Roman spoke only when addressed. His restraint was noted, literally. A clerk typed as he answered. Afterward, a lawyer approached him in the hallway. "You did well," she said quietly. "Not everyone understands when to stop talking." Roman frowned. "Isn't the point to explain?" The lawyer smiled faintly. "In court," she said, "explanations are noise. The record prefers clarity. Clarity without nuance." Roman noticed how other people behaved. Those who spoke too much were gently redirected. Those who challenged framing were politely corrected. Those who remained concise were praised for cooperation. No one was punished. They were categorized. Roman received another update days later. Participation status, stable, not resolved. Stable. The word felt familiar now. He asked a colleague who had dealt with the courts often what that meant. "It means you're not a problem," the colleague said, "as long as you stay that way." Roman began choosing silence more carefully. He stopped offering unsolicited context, stopped correcting minor misrepresentations, stopped reacting when his words were paraphrased loosely. Each time he stayed quiet, the process smoothed. His status remained stable. That was the trade. And slowly, Roman realized the truth. This court wasn't deciding guilt or innocence. It was deciding how much attention you required. Those who complicated things were managed. Those who simplified themselves were processed efficiently. Roman looked at the growing file attached to his name. Neat, organized, increasingly detached from his intentions. And for the first time, a disturbing thought surfaced. If silence improved his position, what would speaking honestly cost him? The shift happened quietly. No notice, no explanation. Roman only realized it when his badge changed color. At the next hearing, the clerk handed it to him without comment. Active participant. The word sat heavier than any accusation. Inside the courtroom, Roman felt it immediately. Eyes lingered on him longer. Questions arrived faster. Pauses followed his answers, as if someone were waiting for him to say too much. He hadn't done anything differently. That was the problem. Between hearings, Roman began to notice patterns he hadn't before. People with active badges sat closer to the center. They were referenced more often. Their past statements were revisited repeatedly, even when irrelevant. Activity attracted gravity. One afternoon, Roman was asked to clarify a point from his original involvement years ago. He answered carefully. Immediately, a lawyer reframed his words. So you acknowledge your assessment contributed to the delay. No, Roman said. That's not what I— The judge raised a hand. Mr. Belak, she said calmly, please answer the question as asked. Roman stopped. He realized then that interruption itself had meaning. It marked resistance. After the session, his status updated again. Participation level. Elevated toward what? Roman requested to withdraw from further participation. The request was accepted, then redirected. Withdrawal is noted, the response read. However, given your relevance, continued availability is required. Required, not mandatory, required. Roman spoke with a lawyer privately for the first time, not to fight, to understand. The lawyer listened, then sighed. You're not in danger, she said, but you're visible. What does that mean? Roman asked. It means the record has learned your shape, she replied. Now it adjusts around you. Roman asked if he should push back. The lawyer shook her head slowly. Courts don't punish opposition, she said. They document it. Roman thought of the file attached to his name. Growing. Refining. He noticed how others behaved now. Those marked active spoke less over time. Their answers shortened. Their presence faded. Not because they left, because they learned. At the next hearing, Roman said almost nothing. He answered directly when addressed. He didn't clarify, didn't correct. The room felt calmer. Afterward, a clerk nodded approvingly. Thank you for your cooperation, she said. His status updated that evening. Participation level. Normalizing. Roman sat at his desk, staring at the screen. Because he understood now. The court didn't care what was true. It cared what was settled. And settlement wasn't a verdict. It was a behavior. Speak less, react slower, accept summaries. The more Roman adapted, the less the system needed to manage him. But with each adjustment, something else receded. His instinct to explain, his need to be precise, his belief that truth emerged through clarity. Roman closed the portal, because a new fear had taken shape. Not that he would lose, but that he would stabilize. And once you stabilize in a place like this, the process doesn't end. It just stops noticing you. Roman was never dismissed from the case. That was the quiet conclusion. No final notice arrived. No ruling with his name highlighted. No document stating he was no longer required. The hearing simply stopped referencing him. At first, that felt like relief. His badge was no longer checked carefully. Clerks stopped greeting him by name. Emails slowed, then ceased. Roman's participation status remained visible in the system. Normal, not closed, not resolved. Normal. Life adjusted around that word. A zoning approval he had been waiting for finally came through. A delayed project resumed. Clients stopped hesitating when his name appeared on proposals. Nothing dramatic changed, which made the change complete. Roman noticed how his behavior had shifted. He no longer volunteered explanations, no longer corrected small inaccuracies, no longer believed that precision was always worth the cost. Silence had become efficient. One evening, Roman met a former colleague for drinks, someone who had once challenged a municipal decision publicly. Heard you were involved in that case, the colleague said casually. Roman nodded. Any advice? The man asked. I'm thinking of pushing back. Roman hesitated. The old instinct rose. To explain carefully, to lay out nuance. Instead, he heard himself say something else. Be selective, Roman said. It goes smoother if you don't complicate things. The words tasted wrong, but they were true. The colleague nodded, relieved. Roman went home uneasy, because he recognized what had happened. The court no longer needed to manage him. He had learned to manage others. Months later, Roman received an automated notice. Case file updated, archival status pending. Pending again. He opened the file. Nothing new had been added. Nothing removed. Just time. He scrolled through his own words, frozen in context he no longer controlled. Sentences he remembered differently. Pauses that now read like admissions. The record didn't lie. It just didn't remember intent. Roman closed the file and sat in the dark. He realized then what the court had actually taught him. Not law, not justice, calibration. How much truth was acceptable, how much resistance was tolerable, how long a person could remain visible before becoming inconvenient. Roman thought of the judge's voice. Calm, neutral, precise. The excerpt is sufficient. Sufficient for settlement, for closure without conclusion, for a system that doesn't need to decide, only to stabilize. Years later, Roman would still hesitate before speaking in public settings, not from fear, from habit. He would feel the old calculation rise automatically. Is this necessary? Is this helpful? Is this worth being noticed? Most of the time, he chose silence. It wasn't imposed, it was learned. And that was the final realization that stayed with him. The court hadn't silenced him. It had shown him the cost of being heard. And once you understand that cost, you don't need a verdict. You adjust, you normalize, you become procedural. Roman stood one evening at a crosswalk, waiting for the light to change. No one told him to wait. Everyone did. And as the city moved in quiet compliance around him, Roman understood the last uncomfortable truth. Justice doesn't always fail loudly. Sometimes it works perfectly, so perfectly, that no one asks what it's doing anymore. Roman began noticing the reflex in places that had nothing to do with courts. At a neighborhood meeting, when a proposal felt wrong, he stayed quiet. At work, when a decision erased months of planning, he nodded. In conversations, when someone misstated his position, he let it pass. Not because it didn't matter, because he had learned the cost of correction. No one asked him to behave this way. No rule required it. It simply felt efficient. One afternoon, Roman was asked to review a junior colleague's report before it was submitted to a municipal committee. The report was accurate, but complicated. Roman edited it down, removed nuance, simplified language, cut anything that might invite questions. The colleague thanked him. "That'll go through much easier," Roman said automatically. He stopped typing mid-sentence. Easier for whom? The thought lingered longer than the task itself. Months later, Roman received a notice. Case file archived. No explanation, no date of closure, just archived. He stared at the word for a long time. Archived didn't mean erased. It meant dormant, stored, retrievable. The record would remain intact, waiting quietly, long after memory softened. Roman realized then that the court had never been interested in resolving anything. Resolution creates endings. Endings invite evaluation. This system preferred preservation of behavior, of compliance, of silence that looked like cooperation. That evening, Roman walked through the city as lights came on one by one. People waited at crossings, filled out forms, lowered voices. No one was being forced. No one was being threatened. And that was the most unsettling part. The system no longer needed pressure. People had learned the rhythm. Roman stopped at the edge of the sidewalk, watching the crowd move in coordinated pauses. He understood now what the court had actually done. It hadn't judged him. It had trained him. trained him to anticipate consequences before they arrived, to simplify truth before it was challenged, to choose silence not out of fear, but out of habit. And habits, once learned, don't need enforcement. Roman stepped forward with the crowd as the light changed. No one told him to go, but he went. Because by the time a system teaches you when to speak, when to wait, and when to disappear into procedure, it doesn't need to follow you anymore. You carry it with you.